Lovely. Thanks so much, Helen, and thank you to everybody who's joined today. We really appreciate it. So today we're going to cover, let's say, the work-based immigration routes under the UK immigration rules. There are separate provisions which relate to family life, private life, asylum and humanitarian protection. We're not going to be covering those today, and indeed that's not an area of my expertise. That's certainly an area that Sam has far more experience in dealing with. So if that's an area of interest for you, then feel free to pop something Helen's way, and we can see whether we arrange a seminar separately on those parts of the immigration rules. So that means we've got half an hour to undertake what is the quickest of whistle-stop tours around the UK immigration rules. These are the immigration rules as they apply today. Like any other legal regulation, things change, and immigration particularly is very, very fast-paced. Things are changed through secondary legislation very quickly and without very much consultation. And so if you are to rely on any of the provisions today, in the future, we would issue something of a health warning. Okay, so the way we are going to divide these slides up will be to consider sort of the point-based system. If I come to the next slide, please, Sam. What is the points-based system? What are the key principles of the points-based system? I'll focus on sponsorship, which is the main category into which workers are from overseas are employed in the UK. And then Sam will move on to the entrepreneurial routes and those routes that are available to citizens of particular countries, which do not require some form of sponsorship. And then I'll wrap things up with a slide on what we'd see as key tips, key issues in the world of immigration from a practitioner's point of view. So hopefully a bit of practice in addition to the law today. Okay, if I could get the next slide, please, Sam. So we're looking at the points-based system. What is the points-based system? It was a system that was heralded in by the government in 2021. However, the points-based system has actually been in existence since 2008. It was introduced by the Labour Party, by Tony Blair, as it was then. So the new points-based system is essentially a revamp of the pre-existing points-based system. And the purpose of it is to set out particular immigration routes which permit individuals to work or to study in the UK. As I said, there are separate provisions for family life, including the EU settlement scheme, which we're not going to discuss today. They fall outside of the scope of that PBS. So there are some provisions in there which permit work that fall outside of the PBS. So you'll have sponsored routes, but you'll also have non-sponsored routes. And Sam will cover the majority of the non-sponsored routes. We also need to be aware of the transitional routes as well. So routes that we can no longer rely on if we were to take a matter up with the Home Office now. But they're still in existence because individuals were previously governed by those aspects of the immigration rules. And so I come back to that point where it is a fast-paced area of regulation. There are regular changes, and so when these routes change, there'll be some people who are stuck perhaps in the pre-existing routes, and we need to cater for those individuals as well. It'd be very unfair to treat them under some retrospective legislation. So as a bit of a cross-cutting guidance, so regardless of whether you've got a route that's sponsored, that's not sponsored, whether it's a transitional route because it's on its way out, there are certain aspects of the immigration rules which apply to all routes in some shape or form. So we've got validity and suitability. These provisions dictate whether or not you can move into a particular category depending on your current UK immigration status, if you're indeed in the UK. They'll also dictate whether or not you should be granted a visa, a person should be granted a visa based on criminality, based on their previous immigration history, based on whether they've got an existing debt to the NHS or to other agencies. So there's a bit around your personal character when it comes to UK visas and immigration. And certainly we do see individuals being turned away at the border. We see people, visa applicants, being refused their applications on grounds of character and suitability. Across many of the points-based system routes will be the need to demonstrate genuineness. So, are you a genuine worker? Is the job you are proposing to undertake in the UK a genuine role? I mean, we see this in the family provisions. Is the relationship a genuine and subsisting relationship? So it gets back to this whole point of a character assessment. And so what we are constantly juggling as lawyers, and what the caseworkers at the Home Office are juggling, is determining from the basis of the paperwork, and the basis of the individual's overall character, the previous dealings, should this person be granted a visa. There will be general grounds for refusal, and again, many of these grounds apply in the same way regardless of route. However, on certain routes, the requirements are tinkered, essentially, they're changed. So what would be a grounds for refusal? Well, let's say, for example, a person overstayed their visa. Perhaps a person took up some treatment at the NHS. They should have paid for it and they haven't. Perhaps we come back to this criminality. Perhaps when they entered the UK, they entered with a clean bill of health, but since then they've got into a bit of trouble. There'll be financial requirements and English language requirements that apply to most of the categories. So perhaps you might have to demonstrate that you have a certain amount of money. And the reason for that is that across most visas, not all, but across most visa categories, individuals will be prohibited from claiming public funds from the government, from taking welfare or other forms of support from the government. Even if you appear eligible for it, the visa will say that you're restricted. There are ways of moving those restrictions and adjusting them, but that's generally the case. So we have to demonstrate a good financial standing. And English language. So normally you can demonstrate English language one of 3 or 4 ways. First, you can either sit a qualifying test at a specific level, depending on what visa that you're applying for. You might have a UK degree taught by a UK institution. If that's the case, that will always provide you with a with an English language. Means that you've met that requirement. You might have sat a degree, passed a degree overseas, which was taught wholly in English, and there'll be a UK agency which looks at that overseas degree for you to determine whether or not you do meet the English language requirement. Or alternatively, you might be a national from a majority English-speaking country, and the rules define which countries are deemed to be English majority-speaking. Each visa will have a particular period of grant attached to it. Now, some visas will just say, if you're granted this visa, you get X number of years in the UK. So an ancestry visa will give you 5 years. A spouse visa will give you 2.5 years. However, a work visa will depend on the contract. So you could apply for a 3-year visa or a 5-year visa. One's more expensive than the other. But if you're on a fixed term contract, a 1-year or a 2-year, then you'd be applying for a visa which runs in line, or which aligns with the period of that employment. So periods of visas will again very much depend on the category that you are applying under. And then, as I mentioned earlier on, there are conditions that are attached to most visas. So I've mentioned the prohibition generally on public funds. Most visas have attached to them a restriction which precludes an individual from becoming a doctor or a dentist, because you have to be regulated and governed by the GMC and what have you. So again, it's a matter of just checking the restrictions, the work restrictions that are attached to the visa that you're applying for. In most of these cases, you can challenge a Home Office decision. Over the years, the ability to challenge a visa decision at a tribunal or at a court have been removed. So in many cases, particularly in work-based categories, your only recourse to challenging the Home Office will be via an administrative review. An administrative review is essentially a review of the original decision undertaken by a more senior person within the team. And if they conclude that the original caseworker made the correct decision based on the information available to that caseworker at the time, then the refusal will stand. What's the impact of this? You have to declare visa refusals in any future UK visa application. But be aware, because if you get a refusal in UK application and you decide that you want to apply for a visa to Australia or to the US or Canada or what have you, then there might be a question in there which asks, have you been refused a visa previously to enter Canada? Or have you been refused a visa for any other country? And indeed, our own UK immigration forms ask that same question. And what they're trying to get at is, what is your standing as an individual? Was it refused on a technicality? Or was it refused because the Home Office didn't believe you, that there's a genuineness issue there? And if it's the latter, then you might find that there's a bit of an uphill struggle in convincing the Home Office to believe you this time around. Alternatives to administrative review will be going to court, to a tribunal, and Sam undertakes his advocacy himself. So that's why we're very lucky to have him at the firm. Most lawyers in most walks of life will instruct a barrister, instruct counsel to undertake that advocacy at an extra cost. Perhaps there's not that rapport with the individual client. So again, lucky to have Sam around, and certainly Sam can talk about his experiences at tribunal if you wish later on. And then finally, with many of these applications, you can bring in dependents. A dependent would normally be a spouse or a civil partner, or an unmarried partner with whom you've lived for a period of 2 years. You have to evidence that. Or alternatively, a child at the date of application who's below 18 years old. There are certain exceptions and what have you, but those would be those would tend to be your dependents that you'd add on to a visa application. Not all routes permit dependents, something to be aware of. Sam, if I could have the next slide, please. And I really need to quicken up here now. So looking at sponsored routes and non-sponsored routes, I'm going to fly through this. So I understand that there are a number of students on today's session. Some of you may or may not be international students, and you're sponsored by your university. By and large, the largest group of workers, overseas workers in the UK, will fall under the skilled worker category, which I'll come on to, or the global mobility route. And I have listed the other examples there, which we are going to, in fact, run through. What I would say is that many of the private and family routes, which I'm not discussing today, do also permit work in some shape or another. And those who enter on dependent visas enjoy general work entitlements. Okay, so sponsorship and sponsor licensing, because this is the main category into which overseas workers will find themselves. We'll just dedicate the next slide to these. So the principle here is that if a UK employer wants to employ an overseas national under the skilled worker route, they need to apply for a sponsor license. They apply to the Home Office for that. It's an online application, and if it's granted, the license is given a period of 4 years, which you can renew in 4-year increments. Under that license, an employer can employ or sponsor any number of workers. This is available to organisations based in the UK that are trading. It also applies to startups. Implied to, and then sector specific, we have particular provisions that rely to care homes, charities, sporting organisations, local authorities, etc. But that's generally the gist of it. You can add overseas branches to your license. So let's say you are a UK organisation, but you have an office in the US and an office in India. And so what you'll be wanting to do possibly is to mobilise staff around each of your entities, your global entities that are linked to the UK organisation. And so by adding those branches or by referring to those branches in your sponsor license application, it means that you can then mobilise staff within the group company and assign them to the UK. There is an exception in terms of under one of the rules which permit non-UK trading organisations to set up, to have a sponsor licence here in the UK if they have no presence here already. That's called the expansion worker category. So let's say, for example, you have an organisation based in Finland, they are operating there and they want to base themselves in the UK. They want to relocate the company. Well, the skilled worker route wouldn't be wholly appropriate initially because there is no UK trading base here. And so they would look to expansion worker rules in order to apply for a license whilst they're overseas. They enter the UK, they establish the license, and then they can start sponsoring individuals from Finland or indeed from any other or anybody else requiring immigration permission. The organisation must have key personnel attached to it. They would normally be employees, but they don't exclusively need to be employees. And those employees who take up the key personnel role must have a specific immigration status in the UK. Those key personnel will be an authorising officer, the equivalent of a COO or a compliance officer, a key contact with whom the Home Office can liaise in respect of that business, and a level 1 user, something we'll come on to in a short while. How long does it take to set up a licence? Once the application has gone in, the Home Office can take 12, but sometimes up to 16 weeks to process sponsor licence applications, or you can take advantage of one of 30 priority slots issued daily. It's on a first come, first served basis, and by paying additional fee, your license can be assessed, not necessarily approved, but assessed within 10 working days. So there are ways of expediting. The fees that are attached to a license depend on whether it's a small organisation or a medium or large organisation. And once the license is granted, the employer, the sponsor, will be granted access to a sponsor management system. This is a portal through which they can report particular matters to the Home Office. Once they have a license, they must also comply with sponsorship duties, which are covered in the next slide, Sam. Those sponsor duties, I will leave you to read those in your own time because time is now sort of playing against me, but they are quite detailed. There's a lot of guidance available from the Home Office on the Home Office's own website, which covers these. Important to note that if you do not get your sponsor type duties correct, then the Home Office can take action against you. So they can limit or they can freeze your ability to sponsor a worker going forward. They can downgrade your sponsor license, they can suspend it so you can't use it, and in worst cases they can revoke it, they can take it away from you. That's typically where they have visited you and they can see that you've not really been taking your sponsorship duties, your legal duties as a sponsor, you're treating your duties carefully and with respect that they deserve. And there will be reporting obligations in the event that police or relevant authorities become involved either in the business or with individuals. So those are your sponsored duties. So once you've got the sponsorship license up and running, you then move on to the sponsored workers. So this is where you can use your license in order to sponsor, to employ individuals in the UK. Most common categories will be the skilled worker, which we've mentioned, and also the global mobility category. So the skilled worker is an individual who joins the UK organisation. They might be overseas, or they might already be in the UK. They commence employment with a sponsor, and then they accrue residence with that sponsor, which normally, after a period of 5 years, in that skilled worker category, they can apply for indefinite leave to remain. So it's your classic work permit route. Alternatively, you've got the global business mobility routes. So you've got a senior specialist worker. Those are individuals who are essentially who are a senior within a group company, but they are based at an overseas entity or branch, and they are brought in and they're assigned a project or a specific time in the UK to undertake some work, but ultimately they will leave. Unlike the skilled worker, they don't need to meet English language requirement, but they may need to be paid a little bit more by way of a salary. You've got graduate trainee routes. You've got the UK expansion route. We mentioned expansion worker based overseas, a business overseas, which is relocating in its entirety or setting up a brand new branch or an entity in the UK. Service supplies are for those organisations which have registered specific agreements with the Home Office, and secondment workers is as it says in the tin. Common requirements that apply to each of those categories and subcategories: you must have a sponsor licence, an appropriate sponsor licence in place. You must meet those suitability and genuineness criteria that I mentioned at the outset. The role must be skilled. A skilled role generally means a role that is beyond college level leaver. So anything above there will be considered skilled, but do be careful because some of the subcategories of global business mobility routes may require slightly higher skill level. Minimum salaries will apply. So the Home Office set out a general threshold that applies to everybody under the various categories. And then a going rate for the specific job. And if the going rate for your particular job is higher than the salary threshold that applies to all categories, then you must be paid the going rate. If the going rate is lower than the standard threshold that applies across all categories, then you must be paid the standard threshold. Those thresholds differ depending on your current immigration status and your age and the type of role and level of qualification that you might be going for. Dependents are permitted under all of these routes, so they can apply from outside of the UK or they can apply from inside the UK if they have a specific or an appropriate immigration permission. And then in terms of the leave that's ascribed to each of these categories, the duration is largely dictated by the period of employment. So it might be permanent employment or it might be fixed employment. The visa will be led by that. That said, under the global business mobility routes, that your leave can be limited depending on how much you are paid. And so certainly most individuals will be capped at a 5-year visa there before they do need to ultimately return to their country of origin or country that they were last living in before moving to the UK. There will be some general and specific prohibitions here because under these routes, the individual is coming to the UK specifically to undertake a particular job at a particular sponsor or employer. So work outside of that arrangement is highly restricted. There are options available to work outside of that arrangement, and the rules set out how you can go about doing it. But generally speaking, the principle is if you're sponsored as a skilled worker to undertake a particular job at X Limited, then that is what you must do. Otherwise, you could find yourself in breach of your visa and the sponsor could find itself in breach of its sponsorship duties. There are some route-specific issues that you need to be mindful of. So your previous employment might be a requirement for some of these, particularly around the global business mobility routes. English language will apply to skilled worker, but it might not apply to all of the global business mobility routes. And settlement is restricted for some of those categories as well. So however much time you spend in that category, that will not count towards the standard 5-year requirement for indefinite leave to remain. It might count towards a longer version of indefinite leave to remain, where you, for example, can spend 10 years in the UK and apply for settlement at that point. There are, I'm just going to rush through these very, very quickly, some temporary work categories there, and they tend to be very specific according to the sector. I would draw your attention to the government authorised exchange, which applies to work placements. This is where an individual is not sponsored by their current employer to undertake a work placement. They're sponsored by a third party which has been accredited by the Home Office, and that party sponsors you to undertake a work placement at the employer. And I think I've probably covered the common requirements there. They really apply each to the temporary work categories that I've set out above. Okay, at this point, I'm going to move things over to Sam. My apologies, I may go over on that part, but we can answer any further questions that you may have on those skilled and sponsored routes at the end of the presentation. Thank you.
Thanks, Glyn. That was a very impressive whistle-stop tour of sponsor licenses and skilled workers, which, as Glyn said, is a very common route for workers seeking to come to the UK. But of course, not all workers are looking to be sponsored by someone. They may not want that commitment, or they may have an entrepreneurial streak and want to essentially work for themselves. The main way in which people can look to do this is the startup route, which is applied for from outside the UK. It can also be applied for from inside of the UK. If you're switching from a student visa or a graduate visa, these are usually the most common routes. And the startup route is for individuals who are seeking to set up a new business in the UK. So they can't rely on something that they've already established. And they have to demonstrate that their business idea is innovative, viable, and scalable. So this is essentially they have to demonstrate that their business or their product, which is being translated into a business, is different from anything else on the market. And it doesn't require a sponsor, but it does require an endorsing body to essentially consider that idea or that business model and put their stamp of approval on it. Now, the Home Office have come up with their own list of authorising bodies, which they feel are particularly well suited to rubber stamping these business ideas. There's a long list online on the Home Office website, and this is regularly updated. So if you are looking or considering the startup route, it's important to make sure that the endorsing body that you are looking to approve your idea is still on that list. Now, the visa itself is a maximum of 2 years, and there's no way to extend it or settle after that initial period. As it says there, dependents are available or applicable on this visa, and there are basic English language and financial requirements. For the startup visa, you need to be able to show that you have a small amount of savings in order to start yourself off in the UK, but you're going to be expected to survive off of your business income because you won't be able to access any public funds or financial support. But you will be able to work outside of your business in order to support yourself. Now, closely related to the startup visa is the innovator visa, and this can be seen as a natural progression from the startup. You can rely on a business that you've created in order to use the startup in the innovator, but if you have not used the startup visa, then you have to not have had a business already in the UK. So with the innovator visa, it's granted for a period of 3 years, and it can be extended indefinitely. It's possible to obtain settlement after that first 3-year period, but there are quite restrictive requirements in place around your business itself. You have to be able to show that your business has developed since your initial grant, and they are measured against certain metrics such as turnover, employees, average employee's salary, and things like that. There is one of the main requirements is that you have a £50,000 investment fund, which is obviously quite a sizable chunk to have, and this is only avoidable if you've been in the UK for 12 months prior and you're switching from the startup route. So as I said, it naturally continues on from that startup route for those entrepreneurs out there who are looking to move to the UK. So aside from the entrepreneurial routes and the sponsored work routes, there are some other routes that you can utilize to move to the UK. And these relate largely to a degree-based education in which you're looking to find your way in the world post-study. The first is the global talent route, which again relies on having an endorsing body to endorse your move to the UK. And this is a route which is used mainly by leaders or potential leaders, and it's in fields of science, engineering, humanities, etc. It can be utilized by the creative arts as well. So, for example, a film star or a TV star or a musician may want to use this particular route in order to relocate to the UK. It's granted for a period of 5 years, and following that, you can apply to settle. And there are general cross-cutting settlement requirements for most visas, and these are the English language test and something called the Knowledge of Life in the UK test. There's also residence requirements, so you have to have been in the UK for a certain amount of time over the period of your 5 years. This can vary slightly from visa to visa, but generally speaking, you cannot be outside of the UK for more than 180 days in any rolling 12-month period. Aside from the global talent, which is very specific, the graduate visa is a very commonly used visa for foreign national students who have finished their degrees in the UK and they're looking to stay and essentially find their way. They're not locked into a specific sponsored work program. They can work, study, and even volunteer freely in the UK for a period of 2 years. The most specific requirement for this type of visa is to have been is to have applied for it whilst your student leave is extant. So that's before your student visa expires. You need to make sure that you apply to switch into this graduate route. It's a very flexible route, and it's perfect for students who are finishing their degree but they're not quite sure what they want to do, or if they just want to spend a few years in the UK to enjoy themselves or to find their feet. The high potential value visa, also known as the high potential individual, is again for a period of 2 years, and it's restricted to those who graduate from top universities across the world. Similar to the those routes which require endorsement, such as global talent and the innovator and the startup route, there's a list online of approved universities, and it is updated regularly. So it's important that if you're an attendee of one of these universities, that you check that your university is still on the list by the time that you graduate. As I said, this is granted for a period of 2 years, but if you are lucky enough to graduate with a PhD from one of these universities, that is extended to a period of 3 years. Similar to the graduate visa, you can have a very flexible time in the UK, where you can work anywhere that you would like, and you can also take some short-term study if you wish, or volunteer. Unlike the graduate route, there's no requirement to have graduated from a UK-based university or to have been on a student visa already. So if you are from one of these very select universities, you have a bit more flexibility when it comes time to applying. Similarly to the other routes, dependents are allowed, but this does not lead to settlement, and neither does the graduate route for that matter. Quickly listed in the other categories are the student visa and international sports person. So with a student visa, it does what it says on the tin, really. You are coming to the UK to study at a UK-based institution. Most commonly, this is a university, and it will be granted for the period of your course, up to a maximum of 5 years. So most regularly, it's granted for a 3-year period to undertake an undergraduate degree, but it can also be used for postgraduate degrees. You need to have a sponsor, namely a higher education institute, such as University of West of England, and they will issue you what's called a CAS, which will allow you to apply for the student visa. And then once that's concluded, you can either switch directly into skilled work if you have a sponsor who's willing to sponsor you during work, or you could switch into the graduate. They're the most common routes. And then finally, the international sports person visa. This is similar to the global talent, where you are recognized in your field as a top tier sportsman, and you will have an endorsing body for your particular sport. So we deal a lot at Newfields with rugby players, football players, basketball players, and the like. So you will have an employer who will offer you a contract of employment. This will generate a sponsor, but you will also need to be endorsed by your sports governing body. This is a very, again, a very specialised route, particularly reserved for sports people. Generally, you will need to have played for your respective nation in international tests. So there are, aside from the previous entrepreneurial and endorsement routes, there are a few routes which are based on your particular country of nationality or a particular category of citizenship that you may hold linked to the UK. So the first, the youth mobility route, this is reserved for young persons, so 18 to 30. I still fall just within that category, but for those people who are from Australia, Canada, Monaco, New Zealand, San Marino, or Iceland, you'd be lucky enough to be able to rely on this route, and it would allow you to come to the UK again under that very flexible term to work for whichever employer would offer you a job, or to study, or to be self-employed, or to volunteer. It's again for a period of 2 years. So most of these flexible routes are for a 2-year period, short term, which is non-extendable. There are some other nations which can take part in this youth mobility scheme. Most recently, India has been opened up to the UK, but this operates on a ballot system. So there are a fixed number of places available every 6 months, and you have to first put your name into the ballot. And if you're lucky enough to be drawn, then you'll have 30 days to apply for your youth mobility visa. Other countries which have a ballot system are Hong Kong, Japan, South Korea, Taiwan. So if you're from one of these countries, then you need a bit of luck on your side in order to rely on the youth mobility route. The UK ancestry route relies on having a connection to the UK in the past. So specifically, this is your grandparent has to have been born within the UK, or if they were born in Ireland before a specific date. You have to also be a Commonwealth citizen or a British overseas citizen or a British national overseas, which are very specific categories of citizenship which are connected to the UK. If you are eligible for such a route, again, you have a very flexible period in the UK where you can work for whichever employer, volunteer, study, etc. But this time it's granted for a period of 5 years. And you can extend that if you so wish, or you can apply to settle. And again, dependents are permitted. The two last routes on the slide, the BNO route and the Ukraine scheme, are for specific nationalities. So the BNO route is in relation to residents of Hong Kong. So you had to have been a resident in Hong Kong, and you also have to be a British national overseas. This is a very specific category of citizenship again. And if you are one, or if you are the child of a BNO, then you would be able to apply under that route. This route is quite unique, where you can either choose a 2.5-year visa or a 5-year visa. So again, it offers you that flexibility, and you can have unrestricted work or study in the UK, and dependents are allowed again. And then finally, the Ukraine scheme. So this is for former residents of Ukraine, or current residents even. And the only requirement is that you had to have been resident in Ukraine before the 1st of January 2022. And if you're seeking to enter, you have to be obviously outside of the UK, but you have to have an eligible sponsor to sponsor your entry. So the main ways that you can have a sponsor is to either have a specific family under the Homes for Ukraine scheme, or the Welsh government and the Scottish government have listed themselves as general sponsors. So they will sponsor the Ukrainian national to enter the UK. Currently, this visa is issued for a period of 3 years, and it does not lead to settlement. But this is a very fluid scheme, and it depends on what happens in the international context. So finally, the visitor routes, these are generally speaking prohibited from undertaking work, and the most common of which is the tourism visa, also known as the visitor visa. And there are two ways in which this can apply. If you're from a non-visa country, there's a list of which appears on the government website, then you can apply for this visa at the border, which essentially involves coming to the UK, and once you land or meet a border official, then they will allow you through for a period of up to 180 days. If you are a visa national, so you're required to make an application before you come to the UK, it's done online, and it can take about 3 weeks to come back. And linking back to what Glyn said in the beginning, the genuineness requirement of such a visa is paramount, really. You need to show that you are a genuine visitor and that you intend to leave the UK upon the conclusion of your period. Now, I said that you're not allowed to work as a visitor, which is the rule of thumb, but there are times in which you can undertake business-related activities, such as interviews or meetings or training or giving a short series of talks. The other category in which you could potentially undertake some work is the permitted paid engagement. This is again a special type of visa which you need to see a border official in order to obtain. It will allow you to come to the UK for a period of 28 days in order to undertake some paid work. We most commonly see it with sportsmen or sports people who come to the UK to engage in tournaments or events or some short-time training, and it will allow them to undertake some paid work. But it can also apply to lawyers, architects, doctors, any sort of particularly skilled profession in which they may need to come to the UK for a short time to work. And then finally, the marriage visa, marriage visitor visa, which is listed there. That's essentially the destination wedding visa. So if you're a foreign national looking to come to the UK to get married, you need to apply for this, come to the UK, get married, but then you need to leave again before your 6 months is up. So that was as quick as I could go through all the visit routes. So I think we're now on to some key points which Glyn will deal with. I think you're on.
Yeah, thanks so much, Sam. Yeah, very good stop tour. So I know there's been a question in the chat, and I'll address that. What are the key points from a practitioner's level? So you've heard a little bit about the law. So how do we operate in practice? So time is always key, and most of our commercial clients have workers that they wanted in yesterday or day after tomorrow, and really it's a matter of managing expectations around there. There are costs, some of which are quite heightened for particular visa categories. Employers can be very mindful of those costs, and so it's a matter of ensuring that they're aware they're aware of how a visa is made up. So normally provide quite a detailed breakdown, because often the longer the visa, the more expensive it becomes. The Home Office, I don't think I could be criticised for saying this, could be quite bureaucratic and lacks really any human element. So you no longer speak to a particular individual or a particular caseworker. Everything is done off-site by a caseworker, and you very rarely have any dealings. So it's key to put the strongest application forward with very good persuasive legal submissions, and with appropriate relevant supporting documentation that marry up with the rules. The Home Office engage with various third parties, so English language test centres, TB clinics, visa centres. None of them are particularly good at being coordinated up, and some of them dispense with advice, which at some time is sometimes at best questionable, at worst negligent. And so you need to be aware of what the rules might be before engaging in the visa process. What happens if you get it wrong? As I mentioned before, a refused visa application can often be, it can often involve in two major things. One, you might have to leave the UK. You might have family that you also need to leave the UK. So there's a huge that could result in quite a major disruption to business. But also it's something that has to be declared in future applications. Is there any impact on that? Potentially yes, because it means that any future visa application could be delayed as a result of a refusal. Lastly, cost. You don't get refunds on certain aspects of the visa process if your application is refused. So several things to be aware of. Knowledge. Be aware, as I said at the beginning, that the immigration rules change very, very quickly with very little notice. Even as practitioners, it's difficult for us to sometimes keep up. There are options to speak to the Home Office. There's a specific business help desk that can take a number of days to come back, and I shall let you decide on the quality of the advice that you receive from that business help desk. There are actually also very few specialist immigration firms. So the size that we are now, we are actually one of the largest standalone specialist immigration firms that do nothing else outside of London. There aren't many of us. Immigration isn't taught at a lot of universities. So really the point of being able to get guidance, tailored advice, the opportunities aren't, there aren't so many opportunities, shall we say, compared to perhaps other areas of law. which neatly leads on to how we can possibly help. So as I said, we are specialist immigration lawyers. Our team are made up of the likes of Sam, who does his own advocacy. We have individuals who previously worked at the Home Office, who were previously involved in constructing things like the graduate visa. We've got individuals who have been at the Big Four, right through to your micro firms. I myself, I think I've been doing this for about 15, 16 odd years. We are just undertaking a benchmarking exercise because all immigration law firms have to publish their professional fees online. For as far as we can see, for all ranked firms in James and Partners and Legal 500, we are the most competitive, and we tend to fix those fees. That said, we're still commercial, and we do cover the entirety of the immigration rules. So a lot of firms only specialise in business immigration or on a bit of private, whereas we cover so the entire breadth. We certainly work with a lot of law firms, and we have no immigration offering. We work with a lot of companies, a lot of organisations that provide us with volume matters. The one question that did arise in the chat, which I'm keen to answer: what happens if you apply for a visa and whilst you're applying for it, your current visa ends? There is a provision called Section 3C. That's Section 3C of the Immigration Act 1971, and that crystallises the individual's pre-existing visa conditions. So if you're a student and you switch to into a work visa, then whilst the application is being decided, your leave is governed by the student visa route until you are granted your skilled worker route. If you're on a skilled worker route working for A Limited and you switch to a skilled worker to be sponsored by B Limited, you cannot join B until your application has been accepted and approved. And that can cause all sorts of nightmares, as you can probably imagine. People are reluctant to resign, offer up notice periods until they've got the new visa in the bag, but everything is very time sensitive. So it is a very interesting area to work in. For anybody on this call who is potentially interested in immigration, then feel free to drop us a note or to keep your eye on the news section of our website. We have just closed an opportunity for a legal assistant in our sports team. We specialise in sports, healthcare, legal, government. I'm sure I'm missing one out, a nasty one out. Those are the main areas that we're working in. But we are shortly due to announce another paralegal role. So I think we've managed to cover everything. It's 1 minute to 2. Have we Helen? Is there anything more that we could add?
No, that's fantastic. Thank you both, Glyn and Sam. My goodness. Yeah, I can see what you mean by having that. There's a lot to cover, isn't there? I certainly had no idea there were quite so many routes, but notwithstanding that, I thought that was a really comprehensive view. I don't think we've got any further questions in the inbox. I know we had a few in advance. I'm just having a quick look. I think on the whole that they were probably answered. We had what kind of help is on offer for lawyers from other countries. Well, I'm guessing that for most people they'd be coming through that sponsor or graduate route, I'm assuming.
Yeah, absolutely. I mean, if you're an overseas lawyer looking to come to the UK, then you'd take advice from, if you were minded to, you'd be able to take advice from any lawyer. You cannot practice immigration law unless you're a solicitor, unless you're regulated by the OISC, or that you fall within an exempt business. It is illegal to advise on immigration, given the implications. So do be careful about who you accept immigration advice from.
Fantastic, thank you very much. I think you answered the question about whether a lot of job opportunities are high demand for immigration solicitors. I'm guessing that there's a lot of immigration work out there, but not many of you doing it.
That's absolutely right. And so traditionally, what you'll have is either your very small high street practices, which largely deal with asylum and private client type matters, dealing with a bit of business, or you'll have your large firms And within those large firms, you'll have a smaller immigration team, and they are essentially value added. So you've got a big corporate client, you do the employment work, the commercial work, etc., but they will also tag on the immigration there. Alternatively, you know, and just to be fair, there are some great immigration firms, standalone great immigration firms in London, so Laura Devine, Fragamans, and what have you, and they are specialist, London-based, very, very good firms. So, but sadly, whereas you could probably pick up employment on every street in Bristol, the opportunity to get into immigration is limited.
Yeah,
sadly.
of course. So I think that sort of covered off the other couple of questions that we had there anyway. So unless anybody is madly typing and we're about to see something else ping into the Q&A, I'll just carry on having a quick chat unless something else comes in. But I just want to say to Glyn and Sam, thank you very much indeed for that. That was fascinating. As I said, we will send out these slides and a copy of the recorded content. So again, if there are areas and you just want to sort of have a go back to them, have a look at them, or you think that there's somebody, if for those of you who are in firms, think there's somebody who would benefit, whether it's your HR recruitment teams or whether it's your corporate commercial employment teams who may not have that in-house capacity, please do feel free to forward that on to them. And I'm sure, as Glyn has already said, if there's any questions that any of you have, then do feel free to drop them a line. And the other thing I would say is on the back of this, again, if there is anything specifically that you would like, that you think we should be addressing as a topic that you're coming up against, and you think we could have a word with Glyn and Sam about putting something on a bit more specific, then do let us know. But in the meantime, I can't see any other questions in there, so I shall let you all get on with your afternoon and just say thank you very much for joining. We look forward to seeing you at future events, and again, my sincere thanks to Glyn and Sam.
Thank you.
Have a good afternoon, everyone. Thank you.